Hello friends, I hope you all are doing well. I am Dr. Gurmanpreet Kaur, Associate Professor of Law at Rajiv Gandhi National University of Law, Punjab. Today we will discuss the topic of maintenance under Civil Law 2, where we will discuss the maintenance of children and elderly or infirmed parents. In the previous lecture, titled Maintenance under Civil Law 1, we discussed the maintenance of the wife under the relevant provisions. So, various statutes in India provide beneficial provisions for the maintenance of the children and parents. The objective of such provision is to achieve a social purpose, prevent vagrancy and destitution, and provide a simple, inexpensive and speedy mechanism for providing support and maintenance to children and parents. Day by day, the old social fabric of our country is shattering. Nuclear families are replacing the traditional joint family, which provided equal support and care for the young and the very old. Western values are creeping into the country, and the young people caught in the rat race of the upwardly mobile have no time for their old parents and the grandparents. There is an exodus of young people from the metros as well as the smaller towns and rural areas for education and lucrative jobs in foreign countries. Many of them do not return. Some try to compensate by sending home the money. So moving on, let's talk about the concept of maintenance under the Indian Constitution. The Indian Constitution is the supreme law of the land. Every measure of intervention, whether through policies or statutes, draws its sanctity from the Constitution. Parts 3 and Part 4 of the Constitution constitute the core of social, economic and political justice in the country. The chapter on fundamental rights does not delineate specific rights for senior citizens. The state has provided enabling provisions to protect particularly the vulnerable groups of society, such as children and the women. Part 4 comprises the directive principles of the state policy, DPSP. These are unenforceable but critical to the nation's governance. The Constitution framers saw this section of the Constitution as the foundation for welfare and democratic governance. Article 41 postulates that concern for old age is qualified, among other things. The state shall, within the limits of its economic capacity and development, make effective provision for securing the right to work, to education and to public assistance in cases of unemployment, old age, sickness and disablement, and in other cases of undeserved want. The Constitution treats human beings as standing on an equal pedestal throughout their lives, without distinguishing between persons belonging to different age groups. However, one must interpret the words used in the Constitution in context as a corollary. It further follows that any policy decision that the government takes must find its hue adapted to the needs of various sections of the society. Therefore, though in the larger frame, the Constitution does not distinguish between human beings of different age groups, their needs are significantly different. Just like the right to life of a child would necessarily include the right to education, it might not be true for people of a different age group, especially those who have crossed the age of 40, and more so in the case of elderly persons. From this perspective, Article 21 of the Constitution is harbour of human dignity for all. But what should be the necessary attributes of life to be dignified at old age will depend upon the legitimate needs of old age. Human dignity is part of life. It is exactness. The 1948 United Nations Universal Declaration of Human Rights recognizes human dignity as one of the inalienable aspects of human rights. To protect human rights, ensuring dignified life for all is the primary duty of the state. Our courts, primarily the Supreme Court, has repeatedly given the right to life the widest possible amplitude. Life without dignity would be a like sound that is not heard. As held in the case of K.S. Puttaswamy versus Union of India, 2017, Volume 10, SEC 1. Unfortunately, in contemporary contexts, a dignified life for senior citizens has taken a backseat. It must be emphasized that the so-called group of senior citizens today played a crucial role in the nation-building process in the past, and the same would be true for the older generations for the times to come. The younger population that is working incessantly today to advance the nation will become part of the elderly population in the future. As a result, the efforts that they put in must be acknowledged and respected once penny human enters the dependent phase of life. Friends, let us now discuss the various statutory provisions for the maintenance of children and elderly or infirm parents. Let's first discuss the provisions for maintenance under the Criminal Procedure Code 1973. Section 125 says the magistrate may order a person to make monthly allowance for maintenance in case where any person, despite having sufficient means, neglects or refuses to maintain, firstly, his legitimate or illegitimate minor child who is unable to maintain itself. Secondly, his legitimate or illegitimate major child, not being a married daughter, unable to maintain itself due to any physical or mental abnormality or injury. Thirdly, a married daughter till she attains majority if her husband is not able to maintain her, or his or her father or mother who are unable to maintain themselves. This section also makes a provision for maintenance during the pendency of the proceedings regarding the monthly allowance for maintenance. The magistrate should decide applications for interim maintenance during pending proceedings, as far as possible within 60 days of serving notice of the application to the concerned person. If a person fails to comply with the order of the magistrate without showing sufficient cause, the magistrate may also send them to prison. So the order of maintenance passed under this section may be altered by the magistrate on proof of change in circumstances under section 127. So moving further, let's discuss the provisions of the Hindu Marriage Act 1955. Section 26 says that during the proceedings under the Act, the court may pass orders with respect to the custody, maintenance and education of minor children. So under this Act, both parents, father and mother or either of them, are liable to maintain the children as ordered by the court. While making such orders, the courts take into account the wishes of the children as much as possible. The court may alter such orders and provisions from time to time. The court must decide any application regarding the maintenance and education of minor children during the pendency of proceedings under the Act within 60 days from the date of service of notice on the respondent, as far as possible. So further, let's discuss the provisions under the Hindu Adoption and the Maintenance Act of 1956. Section 20 provides that a Hindu male or a female is bound to maintain his or her legitimate or illegitimate minor children, and elderly or infirm parents. An aging or infirm parent, including a childless stepmother or an unmarried daughter, must be maintained if they are unable to do so themselves. The court shall consider the following while determining the amount of maintenance to be awarded to children or aged or infirm parents, as stated in section 23, subsection 2. The court considers factors such as the position and status of the parties, the reasonable wants of the claimants, whether the claimant is justified in living separately, and the claimant's income and value of property held, if any. If a person ceases to be a Hindu, changes his religion, he or she cannot claim maintenance under Section 24 of this Act. Section 25 allows for modification of the amount of maintenance if there is a change in the circumstances warranting it. Even the heirs of a deceased Hindu are bound to keep his or her dependents out of the estate inherited by them under this Act, as provided under Section 22. So, as provided under Section 21, dependents include the deceased person's minor son, unmarried daughter, widowed daughter, minor illegitimate son, and minor illegitimate daughter. So friends, under the Hindu Adoption and Maintenance Act of 1956, a Hindu parent is under an absolute obligation to maintain his or her legitimate and adopted children. Since the objective of this act is to preserve the child, the burden is on the father to establish in an action for maintenance that there is no default on his part in maintaining the child. The Delhi High Court held in the case of Chandra Kishore versus Nanak Chand, AIR 1975, Delhi 175, that a Hindu father is obligated to maintain an unmarried daughter, covering both her day-to-day expenses and reasonable expenses of her marriage. A Hindu must meet the marriage expenses of his daughter, regardless of the presence of the joint family property. So, in the case of Tulsi Kumar and Anil Kumar versus Raghavan Nair, AIR 1985, the Kerala High Court has held that the expression maintenance includes provision for food, clothing, residence, education, medical attendance, and treatment. Both parents are obligated to fulfill the maintenance of the child and cannot evade this responsibility by claiming that the other parent has taken over the duty. The mere fact that the child's mother had, as per the agreement between herself and her husband, undertaken the responsibility of maintaining the child does not prevent the child from claiming maintenance from her father. Section 20 holds the father responsible for providing maintenance of his child, regardless of his financial means. The question relating to his means may be relevant only in consideration of the quantum of maintenance. So moving on, friends, the father is legally obligated to take care of his unmarried daughter. The Hindu Adoption and Maintenance Act of 1956 entitles an unmarried daughter who is unable to maintain herself to claim maintenance. So according to the case of Jagdish Chugawat versus Manjulata, decided in the year 2002, Volume 5, SEC 422, the daughter is entitled to maintenance under CRPC when read with Hindu Adoption and Maintenance Act of 1956. So even after attaining majority, but until her marriage, both a Hindu divorcee father and a Hindu divorcee earning mother have an obligation to contribute to the maintenance of their children under the Hindu Adoption and Maintenance Act of 1956. A father is not exclusively responsible for maintaining children, regardless of whether his mother is affluent. So moving further, under the Hindu Adoption and Maintenance Act of 1956, sons and daughters are required to support their elderly and infirm parents who are unable to support themselves out of their own property and earnings. Earlier, only the sons were under a legal obligation to maintain their aged parents. Now, this liability extends to the daughters as well. So, in the case of Jagjit Singh Patia versus Balbir Singh Patia, AIR 2003, NOC 450 Delhi, the Delhi High Court has observed that a Hindu son is personally obliged to maintain his aged parents irrespective of whether he inherits his father's estate or not. The court has also held that his son would be liable to pay a definite amount per month to the aged parents and also the arrears if any. So besides the obligation under the Hindu Adoption and Maintenance Act of 1956, sons and daughters are under an obligation to maintain their parents by virtue of Maintenance and Welfare of Parents and Senior Citizens Act 2007. This act is enacted to provide maintenance for parents and senior citizens. This act casts an obligation on the person who inherits the property of the aged parents or relatives to maintain such aged parents or relatives, and also make a provision for setting up of old age homes for providing maintenance to the indigent older parents. So this act also provides for better medical facilities for senior citizens and provisions for protection of their lives and property. So this act also casts an obligation on children or grandchildren who are not minors to maintain their parents or grandparents who are unable to maintain themselves from their earnings or property owned by them to the extent of their needs in order to lead a normal life. A similar obligation is cast on the relatives of senior citizens who are in the possession or entitled to inherit the property of the senior citizens. So under this act, parents mean mother or father, whether biological, adoptive, or stepfather or stepmother, as defined under Section 2 Clause D. The liability to maintain such relations is personal, not dependent on the possession of the property, and it would cease with the death of the person liable to maintain them. The provision of this section are retrospective in effect. A grant of maintenance allowance is for preserving the existence of an individual who is not able to support himself. The liability of any person to maintain his aged, infirm parents and unmarried daughter extends in so far as any one of them is unable to maintain himself or herself out of his own earnings or other property, as held in the case of Mushma Bai versus Shahji Magan Lal, AIR 1961, Rajasthan 207. The term parent includes a childless stepmother but not a stepfather. The expression parents and children in the personal context would include the adoptive father and adoptive mother. So moving further, let's discuss filing of the application under this act. So an application may be made by the parent or any other person or an organization authorized by him or a suo motu cognizance by the maintenance tribunal constituted under Section 7 of the Act. To implead other persons liable to maintain the parent, the maintenance tribunal, after giving the parties an opportunity to be heard, holds an inquiry for determining the amount of maintenance within 90 days from the date of service of notice of application, which may be extended for a maximum period of 30 days in exceptional circumstances for reasons to be recorded in writing. The maintenance, which will not exceed Rs 10,000 per month, shall be payable from the date of the order or from the date of the application. The tribunal is also empowered to make an interim order for maintenance during the pendency of the inquiry. If the children, without sufficient cause, fail to comply with the order, the tribunal may, for the breach of the order, issue a warrant for levying the amount due and even may sentence the person for the whole or any part of each month's allowance remaining unpaid to imprisonment for a term that extends to 1 month or until payment. So whichever is earlier, as mentioned under Section 5 Clause 8 of the Act. So if the son is in the possession of the property of the father, the son can be directed by the court to hand over the possession of the property to the father if he is not taking proper and sufficient care of the parents. So as decided in the case of Jayant Ram Vallabhdas versus Vallabhdas Govindram, 2013, Volume 3, CCC 119, Gujarat. Further, an application for maintenance may be made where the parents reside or where the children reside, and the tribunal shall have the powers of the magistrate of the first class to secure the attendance of the parties. And if the children are willfully avoiding the service, it may determine the case ex parte as defined under Section 6 of the Act. Under Section 6 Clause 6, the tribunal also has the power to refer the matter to a conciliation officer for amicable settlement, who would submit his findings within 1 month. Under Section 23, it provides that where senior citizens transfer their property by way of gift or otherwise with the promise that the transferee will take care of the senior citizens, the convenience can be declared void if the transferee refuses or fails to provide for amenities and his or her physical needs. An appeal may be preferred within 60 days from the date of the order, and the appellant tribunal, after hearing the parties, may either allow or reject the appeal, where an endeavour will be made by the appellant authority to decide the matter within 1 month of receipt of the appeal, and the decision shall be final. Section 125 of CRPC imposes liability not only on the daughter but also on the son, whether married or unmarried, having sufficient means to pay maintenance to their parents who are unable to maintain themselves. Moreover, a childless stepmother may claim maintenance from her stepson provided she is a widow or her husband, if living, is incapable of supporting and maintaining her. Senior citizens, including parents, will be entitled to maintenance under the Maintenance and Welfare of Parents and Senior Citizens Act 2007, if only they are unable to maintain themselves from their own earnings or out of the income from the property owned by them. Lastly, the Maintenance and Welfare of Parents and Senior Citizens Act 2007 is a most timely and excellent but needs careful study of its provisions. First of all, keeping in view the traditional values, old parents would be reluctant to approach the tribunal to get maintenance. No law can compel you to do good or to be fair to your parents. It is either in you or it is not. In fact, the fear is that stringent enforcement of laws can only deepen the fissures in the society. If a grown adult is publicly humiliated by a tribunal, telling him or her that he or she is wayward and wanting and will have to pay up, there will be further rift and tension in the family. While money to keep body and soul together is important for old people, equally important is companionship, someone to talk in the family, and peace of the mind. Despite the reality of the indifference of the children to older people, it will not be easy to enforce this law. So, to conclude, civilization teaches us the need for a social family system, conceived of as unity. Economic and social pressures have fractured this unity today. There is a need for healing it and making it whole again. A society is measured by its attitude towards the weak, the helpless, and the elderly. Societies that do not take care of the physical needs of this segment of their population have no right to talk about human rights and human dignity. The law enacted may not prove to be a wholesome solution. Need of the hour is that law be applied rigorously and the people are reminded of the great traditions that require care, respect for parents and elderly persons, and the responsibility of the parents to take care of their children. So with this, we come to an end of today's lecture. Thank you very much.